United States Navigating Cargo Claims. The term cargo claim is a broad one. Such claims are ancient with a long history of laws written and rewritten to address them. Cargo claims can invoke maritime law, another broad and sometimes elusive term. Claims for cargo loss or damage on land, never touching a drop of water, are often called marine cargo claims nonetheless. And cargo claim can also invoke air law, laws governing air travel. Most cargo claims are covered by marine insurance. Marine insurance covers, among other things, the transportation of cargo on land, sea, or air. Claims for loss and damage to cargo under a marine insurance policy, when paid, give rise to subrogation, by which the insurer gets an opportunity to try to collect back from the parties responsible for the loss or damage. Through subrogation, the insurer gets to stand in the shoes of the insured, who is most often the owner of the cargo. When the cargo owner, usually the insured, entrusts the goods to someone for storage or transportation, a bailment is created. If the goods move from or to the United States internationally by ocean, that bailment relationship is controlled by the Carriage of Goods by Sea Act, COGSA, as stated of the United States. International shipment not touching a U.S. port may be controlled by other treaties, such as Hague-Visby or Hamburg rules. Interstate and transportation of cargo by rail, truck, and barge are generally covered by the Pomeranian Act and Carmack Amendment to the Interstate Commerce Act. International air shipments are governed by the Montreal Convention (MP4) or the Warsaw Convention. Some personal injury claims are governed by the Jones Act and the Longshoremen and Harbor Workers' Compensation Act (LHWCA), which are left to another day. Cargo claims involve terms unfamiliar to the uninitiated, but which are key to understanding the claim under what is called the Carmack Amendment and COGSA. Such terms include bill of lading. This is a key document for cargo claim. A bill of lading generally serves three purposes. First, document of title. Second, a contract of carriage, and third, a receipt for goods. Ocean bills can be negotiable instrument and control possession of the goods. Manifest is similar to a packing list. It identifies what was packed and or stuffed into a container. Shipper has been defined as one who ships goods to another and one who tenders goods to a carrier for transportation. Carrier has been defined as an individual or organization such as a railroad, ocean vessel, or an airline that transport passengers or goods for a fee. The term private carrier refers to a carrier that transports or delivers goods or services for a single entity, often a corporation. Usually, the entity's primary business isn't transportation but rather something else. For example, a grocery store chain may own and operate its own private fleet to deliver produce and goods to their stores. That grocery store chain's primary business isn't transportation but grocery retail. Its fleet is a private carrier. The term common carrier refers to a carrier whose primary business is the transport of goods and which serve any customers that hire them, such as buses, railroads, trucking companies, airlines, and taxis. Private carriers may refuse to sell their services at their own discretion, whereas common carriers must treat all customers equally. Examples of a common carrier are Federal Express and United Parcel Service. The term independent carrier refers to an individual owner, operator, or trucker who may make deals with private carriers, common carriers, contract carriers, or others as he or she wishes. The term consolidator applies to a company that organizes and often loads into a single container different cargoes to obtain lower freight charges. Consolidators can be found to be carriers if they issue a bill of lading, such as non-vessel over common carriers and VOCC or indirect air carriers. Broker. The term broker means a person other than motor carrier or an employee or agent of a motor carrier that as a principal or agent sells over for sale, negotiate for or holds itself out by solicitation, advertisement, or otherwise as selling, providing, or arranging for transportation by motor carrier for compensation. Marine claims. The ICC Termination Act, formerly known as the Kermac Amendment. What was traditionally known as the Kermac Amendment is codified at 49 U.S.C. Section 14706. It is not known as the ICC Termination Act. It provides the sole and exclusive remedy to shippers for loss or damage in interstate transit. Hughes Aircraft versus North American Van Line. The history. The Kermac Amendment was enacted by Congress in 1906 as an amendment to the Interstate Commerce Act of 1887 to provide for national consistency for good damage or loss during interstate shipment by a common carrier. The Interstate Commerce Commission was abolished by Congress in 1995 with the ICC Termination Act, but the old ICC regulation remained in effect until the new regulations are promulgated. The ICC Termination Act also recodified the Kermac Amendment at 49 U.S.C. This recodification worked no substantive change on the Kermac Amendment. Application. The Kermac Amendment applies to transport of goods between states unless the shipment is within a commercial free trade zone, which is usually about a 50-mile radius from a specified point. Trucks delivering within such a zone are virtually unregulated and can set forth, for example, a $50,000 per shipment limitation of liability. Purpose. The purpose of the Kermac Amendment was to provide a uniform system of carrier liability that would provide certainty to both carrier and shipper by enabling the carrier to assess its risk and predict its potential liability for damage. Effect. If applicable, Kermac preempts a shipper's state and common law claim against a carrier for loss or damage to goods during shipment. It makes carrier liable for the full actual loss, damage, or injury caused by them to property they transport and declares unlawful and void any contract, regulation, tariff, or other attempted means of limiting this liability. The Kermac preempt plaintiff state law claim, which include claim for the tort of outrage, intentional and negligent infliction of emotional distress, breach of contract, breach of implied warranty, breach of express warranty, and violation of the state deceptive trade practices or consumer protection status.